So in their desperation, a certain nameless party decided to go after the police recently. That's right, went after the police, and you can tell from their response that the police, they were none too happy. I don't blame the police for this either, because essentially what this nameless party did is try to pin the blame on them for not seeing what they were supposed to see. They responded May 2016. They said there was nothing there, no crime, so they need their personnel records. Why? Because there has to be evidence of police misconduct somewhere. Certainly, they would have filed a police report that was falsified. Hey, maybe they used excessive force. There has to be something in there to destroy. The police, like I said, they respond to that, and that's what we're going to look at today. But remember, too, they've also gone after Disney. They've decided to go after charities. And yeah, lining up the police, like I said, it's not only desperation, but it is entertainment for the masses. So yeah, get your popcorn ready because this is going to be a fun time. So hey there, to all you wonderful folks, by the way, I hope your day is going fabulously. And if you would, share this sucker around. Make sure you like, you comment. Make sure to play it to the end too, because all of that, it helps it push forward. It gets it out to more people. And you know what? It's absolutely delectable. So like I was saying at the beginning, this is a response by the LAPD to a motion that was filed by the nameless party, a pitches motion. And if you've never heard of that, well, let's look at a brief synopsis here. A California criminal cases, a pitches motion is a defendant's request to inspect law enforcement officers' personnel file for evidence of police misconduct. Defense attorneys typically bring pitches motions as part of a pretrial process when they suspect officers may have acted improperly, such as filing a false police report or using excessive force. So again, essentially, because they didn't walk lockstep with a narrative, they didn't see what they were supposed to see. Back in May 2015, they went on the record saying that, oh yeah, they have to be taught their lesson. They need to be taught that now. Basically, they're going after their jobs, they're going after their life and livelihood, and their argument at the beginning is you do not have the authority, you do not have the jurisdiction to do that. The LAPD appears specifically to contest the court's authority and jurisdiction to adjudicate petitioners' pitches motion filed in special proceedings. They tell them to, through here, we will argue this. We will give any type of oral argument as may be heard by the court at the hearing and will appear telephonically. Now, the introduction, albeit short, is fascinating because it tells you when this started up. The procedure was initiated October 29th, 2019. The petitioner was trying to enforce a subpoena issued under, and they give you the act, the IIDDA, so they break that down and tell you what it is. Because this proceeding was initiated under, and they give a section to maintain another section of the IIDDA, this court's authority is limited to disputes concerning discovery authorized under the IIDDA. A pitches motion is not an authorized method of discovery under the IIDDA, and thus this court must deny petitioner's pitches motion on the basis that the court does not have the jurisdiction to consider it. Basically, what the heck are you doing? Again, you threw that Hail Mary because you know what? You're desperate. Now, this argument is full of legalese, and I understand if legalese is not your thing, but at the same time, if you really listen, what you hear is the LAPD's backhand going non-powdered, dry slap right across desperation's cheek. They're saying, take it, you gotta take it under law. So if you look at this argument here, the IIDA, it was found in Article 1, Chapter 12, Civil Discovery Act. The IIDDA was implemented to clarify the procedures a party to an outer state or foreign case may use to obtain discovery from witnesses within the jurisdiction of California. So you see, they're talking about discovery rules. The IIDA was also developed in response to the National Conference of Commissioners on Uniform State Law's approval of the Uniform Interstate Depositions and Discovery Act. The focus of the IIDA was also to clarify the court's subpoena power. Then you get background, clarity on why this exists, and it's all leading to that big So prior to the enactment of the IIDA, former section, I'm not going to go through this section here, I'm just going to say former section each time, governed the issuance and enforceability of out-of-state subpoenas in this state. The former section authorized a state court to exercise its quote-unquote subpoena power to compel a witness in the state to submit to a deposition for purposes of a proceeding pending elsewhere. Now, the Law Revision Commission noted that former section, it was limited, it created confusion, and it was not applied uniformly within the state. Now, they're going to give you examples of how that worked. For example, former section did not enumerate how discovery disputes could be resolved. In addition, under former section, subpoenas could only be issued to natural persons and not corporations or entities. Moreover, it was not clear whether that former section authorized the issuance of subpoenas for documents only. Now, listen closely, kids. You're going to hear the sound of a backhand drop. The Law Revisions Commission's recommendation was focused on discovery under the Code of Civil Procedures. Not once was a petition motion, which is governed by the Evidence Code, considered or discussed. Basically, what the heck are you doing here? The Law Revisions Commission's recommendation of the IIDDA itself and the statutory scheme leave no doubt that a petition motion is not one of the methods of discovery authorized under the IIDDA. Now, this next part has multiple steps, but it's telling the court essentially, you can shut this down now. You have the jurisdiction to determine whether or not you have the jurisdiction. By the way, you don't, and it's not in your toolbox of discovery methods. You can't utilize this. What's fascinating about it, too, is if this desperation, it gets shut down either right now or if it draws out and it gets shut down later, a certain person is going to have to pay their lawyers for their time, but they're also going to have to compensate the LAPD for their time and money as well. Fun times, isn't it? Fun times. Now, Part A is the reminder to the court that you can shut this down. You can shut it down right now. Preliminarily, the court has jurisdiction to determine whether it has jurisdiction to adjudicate petitioner's petition motion in a proceeding initiated, and it gives you the section. The court has jurisdiction to determine whether it has jurisdiction as a preliminary matter, so they can decide that right here and now, and that it would shut all of this mess down. The LAPD makes this special appearance to contest this court's jurisdiction to adjudicate petitioner's petition motion, as it is not an authorized mode of discovery under the IIDDA, and this court's jurisdiction to adjudicate disputes is limited to only those methods of discovery authorized under the IIDDA. Now, this part, it makes me think that backhand was not only not powdered, but it probably had about 5 to 6 rings on it. Why? Because it's going to spell it exactly why they don't have the jurisdiction. It's going to talk about personnel records, what laws it files under, and yeah, like I said, desperation, it caused overreach, and it's going to cost somebody money. This court does not have jurisdiction to adjudicate the petitioner's petition motion in the special proceeding. Now, this stuff, it's not repeating itself, by the way. Watch, it's going to build an ABC route, and it's going to tell you right away, right about here, why you can't look at personnel records. So the court's jurisdiction they give you the section proceeding is limited to disputes regarding discovery that is authorized by the IIDDA. That section, it presides. If a dispute arises relating to discovery under this article, any request for a protective order or to enforce, quash, or modify a subpoena or for other relief may be filed in Superior Court in the county in which discovery is to be conducted, and if so filed, shall comply with the applicable rules or statutes of this state. This court cannot act in excess of its jurisdiction. Jurisdiction under section, so they give the section, is limited to disputes regarding discovery that is authorized under the IIDDA. Discovery under the IIDDA is governed by the Civil Discovery Act. That's very important. Why? Because discovery of police personnel files, on the other hand, is exclusively governed by the Penal Code section. They give that section, and Evidence Code sections 1043 and 1045. These provisions take precedent over the general discovery rules outlined in the Code of Civil Procedure. A petition motion is not authorized method of discovery under the IIDDA, and it is not governed by the Civil Discovery Act. Thus, this court in the special proceeding initiated under this section does not have the jurisdiction or authority to adjudicate petitioner's petition motion. You can't do it even if you wanted to. So let's go back to A. Now, C is the last part in this matter. It's probably the best too because it reminds me of a certain statement from Apocalypse Now. I love the smell of napalm in the morning. This, it burns away any unclarity. It burns away any argument, and it does it by saying, you see these sections here? Yeah, that stuff, it doesn't work out. It doesn't work out at all. Now, we're going to skip over certain parts. I'm going to read you certain parts to make it work. Make sure you understand the argument, but we're not going to go through all the legalese in it. So, the first number here covers two sections. They tell you these two sections. They authorize a party to an out-of-state case to have a subpoena issued by a court clerk and to have a local attorney issue a subpoena. The subpoenas authorized under this must be issued on approved judicial council forms. Pitch's motion is not a subpoena. It is a noticed motion that may be filed under exclusive procedure outlined under this evidence code section. Thus, Pitch's motion is not an authorized method of discovery under those. So you got to count those out. Now, part 2, it drops the hammer on the idea of ambiguity, telling you under this section, a party to an out-of-state case may seek discovery from a witness in this state with a properly issued notice or by agreement. Now, the legislature intended that section to apply to deposition only. Now, when interpreting statutes, they go through a lot of this. I'm going to read you like 3 quotes here. The fundamental task is to ascertain the intent of lawmakers so as to effectuate the purpose of the statute. The court must assume that when passing a statute, the legislature is aware of existing related laws and intends to maintain a consistent body of rules. And they tell you if the statutory language is ambiguous or reasonably suspect to more than one interpretation, examine the context in which the language appears, adopt the construction that best harmonizes the statute internally with regulated statutes, aka look at this thing. You know what it means, and the court, they're not going to insert words that are not there. They tell them you can't do that. Now, the rest of this, it drops the hammer, and it drops it hard. Why? Because it talks about the Law Revision Commission recommendation clarifying all of this stuff here. And when it's talking about clarifying, it says the following. Evidence Code sections 1043 and 1045 and Pitch's motions are not mentioned or discussed in the Law Revision Commission's recommendation. They say if the legislation had intended to include Pitch's motions and an authorized method of discovery under that section, they would have included language to that effect. The legislature, however, did not include any language about that because that section was intended to address depositions only. So, you see them shut it down there. And then they tell you in conclusion, for the foregoing reasons, LAPD requests that the court hold the petitioner's Pitch's motion is not authorized under that or the Article 1 of Chapter 12 of the Civil Discovery Act. Because petitioner's Pitch's motion is not authorized under that, the court lacks jurisdiction to consider it, lacks jurisdiction over the LAPD. Thus, it needs to be denied for the sake of jurisdiction. Like I said, this person has been desperate. They have been going after everyone. They've gone after Disney. They've gone after charities. They've gone after the LA freaking PD because people didn't walk lockstep, or they gave someone a job, or they're trying to look for an out. Like I said, it is beyond desperate. Some of this stuff is absurd, and you know what it does? It burns money, and it burns it at a phenomenal rate. Now, at the same time, understand why we see desperation. I mean, after all, look at those charity revelations. Oh man, stuff is getting interested, and you know what? We're not even there. We have months to go. But anyway, let me know what you think about this stuff, and as always, I appreciate the heck out of you. You make this stuff possible. I can't say that enough. If you want to help the channel out too, check out our links in the description. We have a few of them, including our comic book. That thing shuts down right in the beginning of February. So if you want to pick it up, there's still time. But after that, yeah, we're getting ready to print. You won't want to miss out. It'll be good.